cardboard litigation. Then there was the wine antitrust litigation, and I got to do baseball trading cards, which was wonderful, absolutely wonderful. And it was also wonderful because our client was the original maker of the bane of most mothers, and I can't tell you how many times I had to cut it out of my daughter's hair, bubble gum. Fleer, a good Philadelphia Quaker company, founded by the Mustons and run by the Mustons as I was there, invented bubble gum in 1928, and their gum was double bubble. Trial lawyers like to set the scene, so here we have in a court in Philadelphia the Quakers, the double bubble, pristine, pure, and on the other side, the defendants are the Shorins and Tops of Brooklyn, New York. And it was like, they even looked the part. Now, I have a lot of respect for the Shorins and for Tops out of Brooklyn. Great company. It just, they didn't really believe in the antitrust laws. So I want to just very quickly be a little educational tonight, and I'll come back to the litigation story. But historically, baseball trading cards represent, and the history of them represent kind of the history of baseball in some ways. But the legal rights that are involved include the original litigation over the right to your own likeness and to control your own publicity and get paid for it. And I guess the best baseball trading card story, and a card that, believe it or not, has sold for $2.8 million, one thin card, is the Honus Wagner card. Now, we all know, I'm sure most people here know, Honus Wagner is that great Pittsburgh shortstop, voted. He didn't make the first one, but the second person voted into the Hall of Fame when it was established. And Honus Wagner, he had his own publicity deals. This is back in the 1800s, because trading cards of different kinds started in about the 1880s, and baseball became probably the most famous one, but there were a lot of others. They had little pictures on them, and they were used, among other things, for advertising the product that they were sold with. Now, the great old American Tobacco Company decided that their cigarettes needed more protection than they were getting in their packs, so they would put the baseball cards in to stiffen the pack and protect the cigarettes more. And they were just making cards. And Honus Wagner didn't like the fact that they didn't pay him for his card, so he actually filed a lawsuit, got upset, and as a result, they believe that only 100 or so of his likenesses actually got put in the packages. Well, that's a collector's dream, to be able to find one of those Honus Wagner cards. But Honus Wagner represents the fact that the player himself owns his likeness and it should be paid for any publicity that's utilized. The cards, then they had to start paying people for the cards. Since baseball was a national U.S. sport, and by the way, in other, Japan, Canada, one other place, maybe Cuba, they also had trading cards and baseball trading cards going back to the early 1900s. It wasn't just the U.S. But I don't have any Japanese cards or Cuban cards. The Cuban ones got put in with cigars, of course. The other legal issues that I'll just briefly mention that are involved here is that the individual contracts with individual players was the way that companies began acquiring the rights to make baseball cards. And one of the things that happened in the contracts was a definition of what was the right that they were selling. And historically, they were selling the right to their likeness sold alone or with gum. Some years they said with confectioner. That became very important because for antitrust lawyers, it's a question of what's the market. The other right involved with baseball trading cards is the right of the owners. The owners own the team logos. So you have the individuals who have the rights to their likeness, the team owners that have the right to the logos, and then the labor movement got stronger and the Baseball Players Association came along and they decided, representing their players, that they had the right to license on a group basis the likenesses of the players. So we have all these rights that become recognized. But basically, the litigation, and there has been litigation in baseball cards ever since the 20s. I think recognizing the value of baseball cards as a market, but also recognizing their value in promoting a particular product. As I mentioned, the American Tobacco Company was involved in this famous lawsuit with Honus Wagner. The cards became involved with gum, and the tobacco companies got out of utilizing them. I guess they were making stronger packages for their cigarettes. But the first company in 1939 to market baseball cards with gum, ironically, was Gum Inc. Gum Inc. later became Bowman, and they produced and sold the cards based on individual contracts with gum until World War II started. Then all the production facilities were involved in other things. In 1948, they again began utilizing individual contracts that lasted for about a year, and then they had a right to extend it to the players. And the players got, depending upon what year it was, $50 a year, $100 a year, whatever. Topps, which, by the way, makes bazooka gum, and as I mentioned, is from Brooklyn, began selling cards in 1951. Now, they had spent a year trying to get contracts. So they're, if you can envision this, is the ball players in spring training are in their locker rooms, and here come these guys trying to sign them up for baseball trading cards. And there are lots of stories about how young players just loved the thought, they were going to be on a card and how they would get maybe $25 or something like that. Topps, though, started using contracts with longer terms, and then they decided to not only sell baseball cards for the players that they had contracts with, but also with people that they didn't have contracts with that Bowman had. So Bowman sued them. And the result of that is Bowman won. So what did Topps do? Topps bought Bowman and got all the rights to the market. So that was in 1956. So for some of us who are doing our card collecting in the late 40s and early 50s, you may be able to find some Bowman cards. The first Topps cards actually came out in 1951. But in 1956, Topps pretty much had the market sewed up. And at that point in time, they were getting contracts that lasted 7 years. So if you can think about it for a minute, these guys going around, and then they started signing up the minor league players. So they had all these contracts that lasted for 7 years. And if you're going to try and compete with them to get contracts, it's going to be extremely difficult. Fleer came along, always wanting to promote their gum. And of course, Double Bubble and Bazooka were fierce rivals for gum. So Fleer came along, and Ted Williams had refused to sign a contract with Topps, but did agree to sign a contract with Fleer. So Fleer put out its first set of Ted Williams cards in 1959. Unfortunately, Ted became ill and retired from baseball, so they only had really 1 year. They then went out, Fleer did, and they got contracts with other retired famous stars, and they put out baseball trading cards of retired players. Then they were doing these contract wars, and they had enough contracts, 67 in fact, to put out a set of 67 cards. That is in 1963. But the set was not very successful. Let me tell you a little bit about the cards, because us antitrust lawyers, one of the things we see in this history is how the antitrust laws really worked the way they were supposed to work. Because the Topps cards, if you're the only game in town, you don't spend a lot of money on the photographers, you don't spend a lot of money on the cards. And I mean, those of us who used to pin them on the wheels of our bikes, no, they were cardboard, and they went blah, 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 blah. They weren't real fancy, and they weren't real sturdy necessarily. And of course, they had the statistics on the back, and that's basically the way you can tell how old the baseball card is for sure. That's the way I tell all these, because I could turn it around and see the stats only go to 87, so I know it's an 88 card. Fleer then sued Topps, that's when I come in, and also the Major League Baseball Players Association, because in the 1966, Marvin Miller, one of the founders of the Baseball Players Association, was a fledgling association. Baseball players back then, you know, it was a lot if you made $25,000 a year. And the association started, and he was looking for a way to get money for the association. And he thought, well, we'll do licensing. And Topps said, well, you know, we have licenses. And the Baseball Players Association said, well, we can license all the players because they've agreed to let us do that. The players didn't want to give up their individual contracts with Topps at the time. I think maybe it was up to $250 a year then. That was a lot of money for some of these young ball players, even in '66. So Topps kept doing its individual contract, but the Baseball Players Association started going to other gum companies, including Fleer, and said, hey, we can get the players to stop signing those Topps contracts if you agree and sign a contract with us. So when 8 years is up, we know you'll be able to produce this many baseball cards, because the players will stop signing those contracts. It was so far away, and it was so much money they wanted, Fleer said, no deal. And Fleer then supported the Federal Trade Commission in the next big lawsuit, which is the Federal Trade Commission suing Topps for unfair trade practices. Unfortunately, the FTC concluded that since other companies could sell baseball cards with other products, that it wasn't unfair competition. Now, how they thought that a kid would go out and buy a loaf of bread to get a card versus going down to the store and getting a pack of gum with a card, I don't know. That to me is not the same market. I have to buy Post cereal. That's right. The cereal, the Post cereal, and I have those names somewhere, all the different ones. Post cereal was one. There were a number of different ones. There was Kellogg's had them. Drake's Donuts or Drake Cakes had them. So there were others. But Fleer disagreed with that ruling, disagreed with what was going on, so they filed the lawsuit. That's the one I was involved in. And ultimately, it was an interesting fight lawyers-wise, because Topps defined the market, and that's what's critical. To show a monopoly, you have to be able to show domination of a substantial part of the market. Well, if the market is just baseball trading cards sold with gum, Topps had a monopoly. But Topps said, oh, no, no, no. The market here is anything a kid can buy for $1 in a candy store or a drugstore or whatever. And so that's how they defined the market, which meant that in our courtroom, they had a 40-foot long candy stand with all this candy and all the stuff you could buy for under $1. Despite their efforts to fatten us all up and sweeten the judge, he disagreed, and he found that, in fact, their contracts and the way that the Baseball Players Association and Topps kept others out of the marketplace was a violation of the antitrust laws, and he issued an injunction, and now we're up to 1980, the end of 1980, and he said that by January 81, that the Players Association had to offer licenses to competitors. And immediately, Fleer and Donruss got licenses, and in 1981, for the first time, other companies could compete head-to-head against Topps with a full set of baseball cards. Now, those of you, some may remember that 1981, what happened to baseball? Huge strike. Huge strike. And by the way, the other lawyer in the courtroom for the Baseball Players Association was a young attorney by the name of Don Fear. He was Miller's assistant at that point in time. He was also counsel for the Players Association. I think he just retired, didn't he, from the Players? Don just retired. Good guy. Well, he's told us that with that long strike on in 81, is that the only time he saw Marvin Miller smile over that 4-month period was when the royalty check from Fleer's came in at the end of the season. And then the light bulb went off, and he said, wait a minute, you mean if I license more companies, we're going to make more money? So after that, even though the Third Circuit Court of Appeals had blinders on and reversed the case that my colleagues and I won for Fleer, didn't matter because of that we lost the battle but won the war, because Marvin Miller said, I'm going to license whoever wants a license. Now, it's a little bit of a problem with this, because on the one hand, for the next couple years, baseball trading cards were gorgeous. They were all different kinds. They came in different shapes. They're beautiful photography, and you can see some of it with some of the examples I brought. But ultimately what happened is that so many cards became available is that their value as collector's items started to go down. And the value of cards after the 80s is a lot less than the older cards. Now my son, unbeknownst to him when he was in second grade, with this history his mother had, a friend of his gave him a baseball trading card packet when he was in second grade, and he thought this was great, and he started on his own collecting baseball cards. And when we were in Chicago, he was 10 years old, and he became then the youngest licensed vendor of baseball trading cards. And one of the highlights, and those were the days that I was kind of the soccer mom and running around looking like this in vans and everything, and I'd go into these baseball trading card shows where my son had been selling and negotiating all these cards, and he would say, oh yeah, this is my mom, you know, she's the one that did the Fleer v. Topps litigation. These guys would look at me, yeah, right. I said, no, it's true, I can tell you some stories. Fleeting fame.